blastmusic247.com. We're changing the industry, one artist at a time.
It's me. Look, hey. Hi, friends. Happy Thursday, also known as Friday Eve. Okay, I hope everybody's having a good week. This week we are talking about wills, trust, powers of attorney, but we're gonna jazz it up and make it a little fun so it's not boring. And we're gonna talk about it not just in the context of planning for death, but also in life because we here now, we need it, right? We need these things. So actually, a trust is a good thing to use. Um, it to buy property. It's a good way to hold your assets because there's something called an asset protection trust, and that's what you put your assets in to shield them from creditors. So there's a reason to have a trust actively that you use every day, besides as a way to transfer property upon your death. Wonderful. So I don't know if there's anyone new out there, but hello, everyone. I am Nichon Mitchell. I'm an attorney. I am located in Texas. I'm licensed in Tennessee, Mississippi. My Texas license is pending. I will be getting Illinois next for all my family because I'm from Chicago and I got family. So I'm also a licensed realtor and a licensed life insurance agent. So I try to be full service for my clients. I am, for a lot of my longtime clients that I've had for as little as a year, 2 years, up to 20 years, I am someone they really trust. And I like to be able to kind of, fulfill all the needs that they have. And it's easier sometimes if one person manages that stuff. So that's why I have all those competencies. Um, and so, yes. So my information on how to reach me, it's going to pop up on the screen intermittently throughout this show. There'll be a way to get the replays. If you guys will if you go to my YouTube channel, I think it's mine, and subscribe, either I guess mine or Blast Media, and subscribe, you can get my replays. And then if you go to my Facebook page for Mitchell Legal Solutions, then if you go there and follow it, you can get the replays. And what else did I want to tell you about me? Okay, well, for the sake of the recording and anyone new who may pick this up and be watching, I've been an attorney for, at the end of this year, 26 years, so just a little over 25 years. I've practiced in government and in private practice. I've worked for, corporations, and I've been everything from a prosecutor to assistant attorney general to a private plaintiff's attorney. I've been a litigation director for a state Medicaid system, and so I have all those competencies. So back to talking about trust and wills and POAs. I wanted to give you guys an interesting piece of information that a lot of people don't know. Well, two interesting pieces, and that I kind of find fascinating. I actually did really good in this class in law school. I enjoyed it. So I want to tell you all about a consanguinity table. And there's something in the law called the degree of consanguinity. What that is a description of how you are genetically related to someone else. What degree of relationship are you related to them? Is it first degree, second degree, third degree? That's important because should you die without a will and you have to go through intestate processes through the state, which is by statute, it has this list of people who will inherit from you. It usually starts with your spouse, then it goes to children, it goes to parents, it goes to siblings, aunts and uncles, cousins. It'll go down the line. The very last, the very last thing it'll go to is the state. That's the very last one. But before that, it'll say any family member within the third degree of relationship. usually you won't see the word consanguinity. That's just from law school. That's the technical term. But it'll in the statute it'll say that anyone related to you within 3 degrees can inherit from you if you don't name anybody. That's becoming more and more important these days because a lot of people are not having children. They are only children that don't have children. I'm amazed at the number of only children I know who don't have children. And so where does their stuff go? And that's one place where it goes. So this is how it works. Okay, so there's a chart that it'll have, and you can look these up on the internet. That's why I'm telling you what the word is. You can put in consanguinity chart. Let me see. Can I post in the comments? I don't know if I can type in there. I think I can. Let me see. Consanguinity chart. Did that work? Looks like it worked. That's what you're looking for. Okay, so this ties into the next interesting point I wanted to make. You know how you see, or a lot of you have probably seen where it says first removed, second removed, third. That's my cousin, 1 time removed. That's my cousin, twice removed. That's my cousin, 3 times removed. I'm going to explain to you how that works. Follow me. Maybe I got some cousins on here. Let me see. I can't tell. I don't see any right now. Okay. Wait. Is that? Okay. So here it is. Take me, right? And I have cousins. I have a whole bunch of them. I got a whole bunch of first cousins. Our parents are brothers and sisters. We all have one set of grandparents in common. In this generation, this first generation, we're all in the same generation, at least genetically. Side note, I have first cousins that range from 30 to 60. So, in the terms of how you think of generation socially, we're not in the same generation, but genetically, we're in the same generation. We're all first cousins. Now, follow me. Our kids, my kids, and all the kids of my first cousins, they're second cousins to each other. And then when their kids have kids, all of their kids to each other will be third cousins. Okay, so now watch this. Me and my first cousins, we're first cousins. The child of one of my first cousins is my first cousin once removed. The child of my first cousin is not my second cousin. That's a mistake that we make a lot of times. But the child of my first cousin is not my second cousin. The child of my first cousin is my first cousin once removed because we're one generation away. And then that child to me is my first cousin twice removed. And it goes down like that. So there's a few different ways that someone could be related to you by 3 degrees. One of them is they could be my first cousin 3 times removed. Or or they could be like an aunt that's a great great aunt, right? Because they start to go out, so that consanguinity table though will help you look on the chart and see who would inherit from me if I just don't have a will, right? But it also lets you know how people are related to you. This is how the law does it. And so a lot of times people don't understand why somebody comes in who never knew the person. They don't even know the family. They were located through some kind of service and they come in and they take everything. That's how they do it because they're related on that consanguinity table. Okay. So the other reason I wanted to cover that first is because that's going to be kind of something that comes up throughout the next hour we're together when we talk about inheritance and where things go to. It's another reason why you want to go ahead and decide who you want to leave things to and how you want to do things. But for now, let's go back to talking about the living because we were talking about trust and asset protection trust. There's also something called a Medicaid asset protection trust. So there's a couple of reasons why you want to keep your property in trust while you're alive. One is you can protect it from creditors, but two, if you have too many assets, you may not qualify for Medicaid if you ever need it in life if you need long-term care. Now, side note, there's something called long-term care insurance. It's very expensive. Most people don't have it. And long term care insurance is what would pay for you to be in a nursing home if you ever had to be in a nursing home. Most people don't have it. It's very pricey. And then people need life insurance and other things they need, so they normally don't have long term care insurance. But if you try to qualify for Medicaid and you have too many assets, and too many assets could mean $2,000 in the bank, the bar is very, very, very low to qualify for. To disqualify you for Medicaid. So if you have too many assets, you can't get Medicaid. So you want to start thinking about, if you're of a certain age, you want to start thinking about what you want to do with your assets, because you can set up a trust in a way where it won't be counted for your Medicaid eligibility, and where you may be able to protect it from the Medicaid recovery trust, which they'll try to do when you pass, and then they'll try to get paid back. Um, Now, something to know about, when I said you can protect your assets from creditors if you put them in a trust, now you have to put it in an irrevocable trust. You can't put it in a revocable trust. It has to be a trust that you can't dissolve. And you have to put someone in control of it. The trustee can't be someone you have control over. So the whole thing that makes your assets protected from creditors is because you don't have any control of them. So creditors can come after you, and they can come after anything that you own or control. So if someone gets a judgment against you, and you have a house or a car, a bank account, this and that, blah blah blah, you have all that stuff, they can come after it because you own it. If you have your stuff inside of a trust and you don't own anything, the trust owns it. The trust owns it, then they can't get to it. The trust will own it. The trustee will distribute it to you for your benefit. So, if you do this, of course, it needs to be someone you trust who will distribute your or hold your assets, whatever you want done with them. They'll do it in a way that benefits you. This is a reason why you want to have a personal family lawyer, an attorney who does your estate planning, your estate work, who helps you plan things before you buy a house or buy property, or before you get anything, call your attorney, because they can help structure this. This the main benefit over, because a lot of people say, well, you can get on. Now I'm drawing a blank because I'm on here. The sites you can get on, and they say you can do a will for $199. You can do a trust for $299, whatever, right? That's the main reason you don't want to use those, is because depending on what state you live in and what your very specific needs and wants are, you need somebody who's going to draft exactly what you want and what you need. And a lot of times those services, they might lure you into and say, hey, get a will for $199. And then they have that little button that says talk to our attorneys. You may end up needing an attorney anyway and paying, because nothing in this area is one size fits all. Everything is a unique draft to that family or that person or whatever. So you want to keep that in mind. Now, you want to set up a trust with your assets in it before you ever have a creditor claim. If you try to set up the trust once the creditor is coming after you, that could be considered a fraudulent transfer. So it's kind of like having a car accident and then calling State Farm. No, you had to have had them beforehand. So you want to be thinking about these things in real time now, about how you're going to protect. Everybody. People. Some people say, "I didn't think I had enough for a trust." We're all working hard for whatever we have. So whatever you have, it's worth protecting. And so you want to start thinking about that. And the other thing is what I said about the Medicaid Asset Protection Trust. If you're trying to put your property in a certain place so you can qualify for Medicaid, there's a look back period on that. And at this point, I think it may be 7 years. And so that means at the point you apply for Medicaid, they're going to look back that many number of years and see what assets you had. And whatever you got rid of in that time period, that's not going to count. You had to have gotten rid of it before the look back period when you're applying for Medicaid, if you need help with Medicaid paying for long term care. So You can't, just kind of get old or get older. You need to be in a nursing home because your family can't take care of you. And then you start giving assets away then. That's kind of not, that's for the most part not going to work. There's a look back period and you will have to have done it then. So, in terms of purchasing property, so what you would do is you would generally have a trust set up anyway. You like my trust, I use the same one that I use to say where my property goes when I pass. That's the same trust I use to, like, me and my husband used to buy our house and do different things like that. And the other thing with using a trust is you can stay anonymous a lot of times because the trust is making a purchase. Your trust can buy stock, it can have bank accounts, it can have its own tax ID number and file taxes. So it's a way you can operate and have some anonymity. You can own property and people not know it's you. So that's just something though that you would want to make sure the attorney knows when you are setting that trust up, that you're gonna, want to be buying property and different things like that. And there's also a way to put your business in a trust and run it through there as well. So there's a lot of options, a lot of reasons, a lot of ways you have a trust actively using it right now. Um, so, okay. So, wait a minute. Let me make sure. Let me see if there's questions about that. Okay. I don't see any questions. Okay. So, alrighty. So, oh, yeah, no questions. Okay. So, all right. So, moving on to having a trust in order to decide what you want to do with your property. Oh, you know what? Before we talk about trust, this is the next thing: powers of attorney. Let's talk about those because we need those. Those are a good foundation for periods of time where you are unable to handle your own business for whatever reason. It doesn't have to be that you're sick or you're in a coma or anything like that. It could be various other reasons. So there's powers of attorney, a durable power of attorney, and then the healthcare power of attorney, which in a lot of places is a living will. Okay. So you could give someone a power of attorney to do anything that, so basically that person is your agent, you're the principal, they're going to act on your behalf. So like right now, if a real life circumstance, and I always just like to use, so I can use circumstances from my life because you know it's just regular stuff that people go through, and then maybe it'll help y'all understand. So, if y'all were watching last time, y'all know my dad passed in 2022, and we're still in probate. A reason to have a trust, y'all get a trust. Okay, so we're still in probate. There's a bank account out in California. I'm in Texas. My sister's in Tennessee. One brother's in Illinois. One brother's in Iowa. But everything with daddy is out in California. There's a bank account out there that has $5 in it, and the bank is sweating us. They said you got to come in person and handle it. We got to go in person to close a $5 account. Side note, why is there $5 in it? Because it was one of them credit union. You know how we do. We just put the minimum in to be the member, and then we open it up. So he has this account has $5 in it. They won't close it over the phone, online. They won't let us send documentation, nothing. We have to go in. So what I've been thinking about doing is we have a friend out there that we trust, is giving her the power of attorney to go in and close it. The only reason I haven't done it yet is we need to call them and make sure that they won't clown us. So what they're going to do is they're going to call their legal department and make sure that it's in their policies and procedures to let her come in with a power of attorney and do it. But that's a good reason to give somebody, that's what's called a limited power of attorney. So sometimes you hear about giving somebody a power of attorney and people always think it's the whole basket. Like you have to, when you give someone a power of attorney, you have to give them the right to do everything. You don't. You can give someone a limited power of attorney. That's what she would have. You only have this power of attorney for the limited reason of going into this bank and closing this account. They can't do anything else with it. They can't pretend to be you anywhere else or do anything else with it. That's why it's limited. A durable power of attorney gives someone a whole bunch more power. Now, it's the power that you want to give them the way you designate it, but it gives them a lot more. That's why it's durable. It covers everything. It's going to cover banking, your health, your day to day life decisions, stuff. It's going to cover all of that. And so it's durable because it's one power of attorney that's going to cover a lot of different things. But once again, only the different things that you want to let that person do. The power of attorney is going to be ineffective once the person dies. Once the person dies, that's when you need the will or the trust. You can't continue to transact business on the power of attorney once they pass. You need another document. So that's another big thing that I see, and it's a misconception that people have. Um, Usually, if you go to a bank or any institution, kind of, just the settled, the set, they have policies and protocols and rules about powers of attorney, and they will say we can't take this any longer, and you would need another document. So, oh, here, let me see. Someone says, how much does this usually cost to get set up? Okay, so um, a trust can it depends. They can range very much on the low end. The low end is $3,000. That's really just a single person. I'm 25, 26, 28 years old. But look, a lot of 25, 26, 28 year olds got houses and money, and they got business. They just don't have any children yet. They're not married. They don't have an extensive portfolio. They're single. It can range from that all the way up into, it could be eight, nine, $10,000. That's usually somebody that's married. They got a few kids. They're setting up some special provisions. They want to. Usually, the attorneys that I know they'll charge an extra 2,000 to add in a business, stuff like that. I hover in the 4,500 to $6,000 range, depending on what you need, and that's not the single person that I said was on the low end. Um, I hover around in there, the ones I've been doing just based on what they need. Um, but that's a document that, um, for the most part, the structure of it should last a long time. It's just in the like I said in the last broadcast, you we should meet every 3 years and check on it, or we should meet when you have a life change. For me, I don't charge for changes like in the first year. Like in the first year after we do it, I don't charge to make changes. Um, and then we should check in at 3 years. So that price range, it includes so many different things. Like I said, it's depends on what you're trying to put in it. It depends on what stage you're at in life, who you're trying to provide for, and it depends geographically where you're at. Some parts of the country it just costs more than others, but it's that's still kind of a basic. That's a good guide for what the pricing is. Does the person you put in your will or trust have to be blood relatives? Does the person you put in your will or trust have to be a blood relative? Absolutely not. No. The person, I would say the best answer to that is the person that you put in there should be someone you trust basically with your life. Someone who either would will do what you're asking and will do what you say, um, or they will exercise great judgment if you didn't leave any instructions or whatever. Like if something happens suddenly, and it's somebody who has good sense and who will exercise good judgment. So um, yeah, like even like from the first time I was married, he said he didn't really believe in life support, and he was like, and I'm just gonna pull the plug, something happens to you. I was just like, whoa, because I'm fighting. Like whatever's going on, I'm fighting. I don't even want you to turn the light off when you leave the room. Leave everything alone because I'm fighting to come back, right? So even though I was married to him, he was not the person on my healthcare power of attorney. He was not the person. It was my brother. Because me and my brother share similar principles and thoughts on the matter. In that if there's any chance that I can fight my way back, I'm fighting my way back. So don't pull the plug on me. So even though I was married to him, he wasn't the person that was making the decision. So that's just an example, once again, of how you can do something different than usually either what people think you have to do or what's customary. No, it does not have to be blood or family member. Now normally normally the person who's the trustee is not someone who would take under the trust, and the person who's the executor of the will should not be a beneficiary under the will. That's something you can talk about with the attorney if you have limited options, because a lot of us only have a few limited options on who we trust that much, right? Who will I trust with these things, or to take my children, or to make sure this stuff is done? We only have a limited number of people. And so structuring that is important. And that's another reason why you just want to go ahead and have an attorney that's handling that for you instead of using one of the online services. I'm not bashing them or saying they're not good to do. I'm just pointing out reasons why, because a lot of times in order to market something, or to get people to latch onto it, they'll make it sound a lot easier than it is. Now, the one thing I will say about these companies is it's at least getting people to think and at least get the gears going and get them in motion to get the documents that they need, because it does make it more affordable. But you have to think about how many gaps is it missing? What is it not considering? What does it not know about you personally that should be in that document? Because you could pay $200 for a document, but if you die and your kids still end up in CPS custody until somebody can come get them, it didn't work. I mean, so you want to think about that as well. Okay. So the very first thing I would recommend is, and to start small with people, is let's get you a healthcare power of attorney and a durable power of attorney. And so I'm probably going to do is set up a workshop where we have 3 meetings, and we're going to have one meeting where we fill out our document, and we're going to have a second meeting where we talk about what exactly it is that you need. And then we're going to have a third meeting where I produce your document for you, and you check it and make sure that it's everything that you need. And then at the end of 3 short meetings, you're going to have a healthcare power of attorney and a durable power of attorney. You'll have those 2 things. That workshop to get those 2 documents done is going to be $250. And if you want more information on that, just there's an email address. You can use that email address. That's fine. I actually want to give you, I'm going to put another one. I'm going to put this in here. Financial, legal. Okay. So if you want to do that, then send me that, because I'm going to try to put just like a small little class together. That's what makes it affordable. If I can, if we can get on. Now, when I say we're going to get the information together, I'm going to email you a form, either a jot form or a fillable form, and you're going to put your information on it. But the biggest hurdle that people have is getting all this information together to get me to do their trust, their will, their power of attorney. They have a problem getting all that together, right? So I'm just like, we're just going to have a small little workshop where we start, and it's going to be 3 short classes. They may be 40 minutes, right? We're going to fill our paperwork out. We're going to talk about exactly what we need. And then in the third session, we're going to have the 2 documents. We're going to check them over. We're going to make sure they're right. And then you'll have a healthcare power of attorney and a durable power of attorney. So that's what that workshop is going to be. So based on interest or whatever, then I'll schedule it. so that it'll be maybe 3 to 5 people in each workshop. That'll keep it small. And then that's a way too where you can ask questions. So it'll be like a group aspect of it, but there'll also be time for you to talk to me privately one on one. Okay. So there's that. And let's see. Okay. So producer, is it time to take a break? I should look at my, let's see.
Sure, we could do that. It's almost it is the midpoint now.
Okay, so for those that are new or just now joining, Blast Media is a platform that features up and coming artists, new artists, or artists with new music. And I like that aspect of it, which is one reason why I chose this platform. And I'm a music person. I grew up in the 80s. And so I like it. So I hope you guys enjoy the song that he's going to play. And it's also a time, hey, let's refresh, get our notes together. You guys can think of questions to ask me. And we'll start back up when we on the other side of this break. Thank you.
Indeed. So thank you, everyone, for coming out tonight. And our blast artist of the night, her name is Christina Michelle Sayers, and this song is called Keep Moving. Let's check it out.
He'll be a creator, he'll be your supply. Cause the race is not to the swift, nor the battle to the strong, but whoever endures, that's who will win.
Put your hands up to the sky. Don't let the pressures take your life. Just keep moving. Just keep moving. Just keep moving. Don't you give up. Just keep moving.
Yes, indeed. And that was Christina Michelle Sayers with Keep Moving. And if you are an independent artist, a spoken word poet, or up and coming comedian looking for some exposure, you can go to blastmusic247.com and register for free. Blast is also looking for the fans, excuse me. If you're a fan of great music, you too can also register at blastmusic247.com. Register as an unlimited fan and get access to hundreds of independent music. Blast, we're constantly changing the industry one artist at a time. All right, Nichon, back to you.
Yay. Okay. I wish with all my heart, y'all, I could sing. I cannot. Okay. So alrighty. So no questions yet about anything that I've said about like using the trust to buy property, using the trust to hold property, using the trust to also, okay, so you can also have provisions in your trust that keep your family members or whoever you leave this stuff to from giving what you left them from giving it away. If you all have concerns about that, that's also possible. There's a provision in there you can put called a spendthrift provision. Oh, the other thing to know about trust, I'm just trying to give y'all everything I think you should know for when you inquire or if you want to get one is just to be clear on the tax implications. Now, the the inheritance tax is, I believe, like your estate has to be worth more than like $12 million. Most at the federal level. State laws will be different. So another thing, that's another reason too that you would want to, and just depending on how much you're putting in your trust and how much you plan on leaving, because we may not have a lot right now, but sometimes we leave a lot of insurance money and you just want to check on what the tax implications would be. And so you would also want your trust set up in a way where whoever you're leaving it to, there will be no tax implications to them because you want them to have the actual money or the actual asset and not be burdened with a lot of taxes. So while the federal threshold may be really high, you want to check in the state that you're in and see what the state threshold is for any estate assets and money and property that you would leave. Okay, let me think. What else I want to tell you about trust? Oh, well, okay. So we haven't really talked about wills. So there's actually a lot of different ways you can do a will. So in some states, they allow you to do what's called a holographic will. That's when you actually handwrite your will out and sign it, and you say, okay, this is my will. You can just handwrite it out. Now, keep in mind, there's some limitations to holographic wills, and that's for a really good reason. So, like in Tennessee, you can't give away real property in a holographic will. Some states say you can't give away more than $1,000 worth of cash in a holographic will. But if you quite literally don't have a lot, or if you are in a situation where you would like to write something down, a lot of states have that provision. So what you can do, and I'm going to put it in here right now, so you holographic. Okay, so So what you want to do is you can put holographic will in Tennessee or holographic will in Mississippi. Now this is just some kind of preliminary research that you can do before you actually talk to an attorney and see, okay, some states don't even allow it. So first, are you in a state that allows one? And if they do allow one, then what can be in it? So here, let's see. I can look real quick. I'm multitasking over here, y'all. I got a laptop up. Let's see. It's been a minute since I've looked at the Tennessee statute for this one. Let's see if it'll tell me real quick. Tennessee Code annotated 32-1-105. The entire document must be in your handwriting, and you must sign it in a way that clearly indicates an intent to finalize it. And the biggest contest to that will, of course, be like, is that your signature? And let's see. It has to clearly express your desire to give away the things that you're giving away inside the document. You have to say, I'm writing this because I would like to make this my final will and testament. You have to say that it's your final will and testament. And that I'm doing this because I want to give these things away. And you don't have to have any witnesses. You don't have to have any witnesses to you writing the will, but in court, 2 witnesses would have to testify that that's your signature. So, yeah. So what would happen is you'd have this handwritten will, right? And then somebody would find it in your family, and then somebody else would say, that's not them. She would have never wrote that. And then it'll end up in court. And then they'll have to prove that's your signature. Another family member might put on testimony that you would have never wanted that because they have something else that you said. They got text messages, they got this and that, all that kind of stuff. And it just a lot of times creates a big mess. So while a holographic will is an option, it's not a good option, right? So the best option is an option where people you don't even give people room to fight. There is no argument. And for the most part, from what I've seen, if there's room for a fight, there's going to be a fight. When you take the fight out of it, then people mostly just have to do what you've already said to do. The other thing I want to point out, because I've seen a couple of, not Facebook, I think I maybe saw them on Instagram, but there's a lady that does posting about wills and estates and trusts. And she told a story about a man and a woman. They were living together. They were not married. She had some grown children, but they were young grown, like 21, 23. She had some children. So it was her house. She owned the house. He moved in with her and was living there with her. So something happens, like there's a car accident or something. She passes. He goes into court and makes the argument to the judge that she told him that she wanted him to have that house. And that because he had been living there and paying rent and helping upkeep the house, he was entitled to the house. And the long and the short of it is, after she told this story, the kids, of course, had to put up a fight. But imagine you're 21 or 23-year-old, having to figure out how to do all this, right? The kids, have to get a lawyer. They have to go to court. They have to fight to get the house, the doors that they were expecting to be theirs, except for this man, this boyfriend, put a fight up and actually had a real chance of getting it. So at the end of the day, I believe the kids ended up with it, but at what cost to them? And I'll tell you about another close family member that I know. Her father passed, and he didn't leave anything. He had 2 children, 2 different mothers, but at the time he passed, they were very grown, like in their 40s. And by the time she finished probating that and dealing with fights from his sisters, his other child and stuff like that, there was literally nothing left. So what happened in her case, real quick, in Tennessee, was that she didn't. So if you all were watching on the last show, I talked about how when someone passes, family members go to court and you do something called a petition to open the estate. So that was done, but it wasn't granted in favor of her or anyone else. The estate ended up being run by the clerk of the court. And that can happen sometimes. The estate ended up being managed by the clerk of the court. When that happens, you got to pay the clerk 5% of the value of the estate. And of course, the longer it draws on, the more you pay the clerk, the more you pay the lawyers. And so really by the time it was over, there was nothing left. And then the clerk of the court, they can say, oh, well, this house is just been sitting over here and both the daughters already own a home. It doesn't look like they're going to live over here, so I'm going to sell it. Now, you may not want to sell your daddy house. You might want to keep it and rent it out. You may want to do something else. But if the clerk of the court has been appointed to be over the estate, the clerk of the court is going to determine what goes on. So there are instances when if you have a will and it ends up, well, it's going to end up in probate. The only question is how much fighting is going to happen. But it could, if there's too much fighting and the judges don't want to be bothered, he's going to put a disinterested third person over that estate. It could be the clerk of the court, or it could be some other in the community, like a local attorney or CPA or somebody who has been a trusted trustee before for the court, and the court will appoint that person over your family heirlooms. They're going to get to tell you if you get your family picture book. They're going to get to tell you if you get to keep your mama's jewelry. They're going to get to tell you all that kind of stuff. That's another reason why a will is not ideal, because it's definitely got to go to probate in order to be put into effect. And then because we all got people in our family who don't have good sense. Come on now. Look, as my little sweet daughter like to do, look, we all got people in our family that don't have good sense. When they come a knocking and they want to come fighting about something that was never there, it was never even be theirs. It's these ancillary people that come up and they want something that was never theirs. And the fight is real. And this is a harsh statement that I'm about to say, but I'm going to say it. If you are a single parent and you have children and you have no provision set up for what's going to go on with them, if you're not here, you are not doing your job. Because I mean, what? You're just leaving them out there. And that's a statement that I feel strongly about, probably based on a lot of what I've seen. When it's too easy to do these documents. I quoted earlier my range kind of, but I'm not the attorney that's like, I want all that up front. I'm willing to work because I'm really passionate about people having these documents and having what they need. I will work with you on, payments, that kind of thing, because $4,500 to $6,000, and y'all look, that's a reduced price. All of my friends, because I'm in a group of attorneys that do estate planning, they start at $6,000 and $7,000 and $8,000. That's where they start. But for me, because it's just like back when cell phones were all, $2,000 back in 1997 and nobody had that. And now you can get an iPhone for free. You got to make it affordable for the people for them to do it, So I'm passionate about people having their documents, just because in my practice, when I've done wrongful death cases as a plaintiff's attorney, and I've seen what happens to families and what fighting goes on, and just in all my different capacities as an attorney over all these years, it's too easy to do this paperwork and get stuff done, especially if you do it. I'm thinking a lot about this, and I just really think I want to do workshops that move people along in the process and get them towards the end, because how it does work and how it works with other attorneys is, like, for me, how it works is, I need all the information I need from you, right, in order to do your trust. Like, remember I said my trust is like 60 pages long. It's a lot in there, right? So I send you an intake document that's like 16 pages long. It has all the information in it that I need to do your trust. And I meet with you, of course, right? So what I'm noticing in my clients is they will not get these 16 pages done. It's like pulling teeth. And then it just falls off their radar. They stop working on it. And then they in about 8 more months, they go, oh, you know what? I need the trust. I need to get back. I need the trust. I need the trust. And I'm just like, so what I think it's better to do is, that's why I'm like, we can have a small workshop. And a lot of times people have questions too on the 16 pages. But I have to explain to them, like, I need everything. I just told y'all about like a lot of different scenarios and how everything is very unique. It is set toward each person. And so I need all of that information so I can make a trust for you. The trust that works for me may not work for you. I can give you ideas on what you can do about the one wayward child you got and the one good child you had, or, you know, all of your kids are wayward and you like, I'm leaving it to the ASPCA or whatever you're doing. You know, I can give you suggestions or ideas. We can talk about that. But yeah, it's too easy to get the stuff in place that you need to have in place in order to make stuff easier for everybody. So going back to my dad, whose whole daughter is a lawyer. And I'm like, Daddy, you need to trust. Yeah, I'm gonna do it. I'll get to it. I'm gonna do it. And even his neighbor was like, yeah, we have a trust, you know, for our house. And he was out in California and already knew the whole back and forth. I knew we were gonna be engaging in that if something, because he kind of just had some lifelong health issues and some that developed as he got older. And then nobody wants to deal with California like that. I mean, it's cool to go vacation out there and hang out in Hollywood and do a few things, but no, like business and living out there and stuff, no. So I already knew that. And it's been every bit of the nightmare that I knew it would be. And I'm just like, okay, he didn't even have to do all that. And so sometimes people hear me say, if I could dig him up and smack him, I would, because it was too easy for him to do something that didn't have me and my brothers running out to California all the time trying to handle his business. Like, that's just like, you know, a burden that you shouldn't want to put on your kids. I think there's a question over here. Let's see. Oh, hold on. What I said, trust is better to have than a will. 1000% absolutely, for the reason I just said about the court nonsense and mayhem with a will. What's all included in the estate planning package? For me, in my package, I do both the healthcare power of attorney and the durable power of attorney. I do the trust and a pour over will, and I do free updates for the first year. That's what's included in mine. Now, that's not normal. I'm just going to go ahead and say that now. Like, now look, I'm saying free updates for a year, but that don't mean y'all can call me every week with an update. Like, mostly when we get it done, it should be done, but something may happen in the first year. Like, you may pay your car off in the first year. When you get the title to the car, then I help you put the title in with a trust. I give you the instructions and stuff how to do it. Some of the stuff you got to do, I just tell you how to do it. Some of the stuff I do, and it might mean your trust needs updating. And I have to go into it and update it. So that's for me, because going back to what I said, I'm passionate about everyday people, because everyday people, they think trusts are for rich people, and that's not true at all. If anybody needs it more, it's, you know, middle class, lower middle class. It's those people, because our families can't afford lawyers to go to court to try to keep the house that I grew up in, or keep the house that was my mother's that should be ours from the boyfriend who was living there and now thinks he should own it. You know, if anybody needs it, it's us. But to that point of rich people, there's a lot of tips we should take from rich people. Now, when I have my episode on divorce and custody and child support, I think that's March 19th. When I do that one, I'm going to tell you about, you know, like, you know, when rich people, or you see stars get divorced, and, you know, you don't see much, but see the divorce is filed, and then a document is filed that says the parties have come to an agreement and this case is over. You too can do that. So we're going to talk about that then, but this is the rich people tip this week. So you see, you know, the rich kids and the rich people, all kind of stuff, like what they're doing. They have their stuff in a trust. A lot of times their stuff is in a trust, and they don't have access to it. divvied out to them. Now, sometimes you'll hear whoever was running their money absconded with it, stole some of it, took it, blah, 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 this, that, and the other. And now they don't have their money. They had a trustee they couldn't trust. But in terms of making themselves judgment proof or not having access to a lot of assets, now look, a lot of them don't do it, but the smart ones do it. The biggest, probably most popular one to think about is the Kennedys, right? All that is trust. That's trust money, and everything is on the house in Hyannisport and all that kind of stuff, right? So that's how the stuff is owned by trust, not one individual family member, but the trust owns it for the benefit of who? The entire Kennedy family. And probably the way they have theirs written is you have to be a blood lineal descendant of a Kennedy, I would imagine. This keeps so what's never going to happen in the Kennedy family is one of those Kennedys is not going to marry somebody and they end up with Hyannisport, or they end up with property that originated in the Kennedy family. That's never going to happen. And so, and they make sure that doesn't happen by keeping it all in a particular kind of trust, and probably not just one. It may be 3 or 4 different ones for different reasons. This trust is set up to hold real property and take care of houses. This trust is set up to send all the Kennedy kids to colleges and universities. This trust is set up, it's probably something more like that. Okay, so that's what's included. That's LLC's need. Yeah, you can do an LLC for sure. You can actually do an LLC to run your day-to-day life. You can have, like I run a lot of my expenses through my business because they really are business expenses. But you can actually set up an LLC to run your personal everyday life and write a lot of that off. It's a fantastic thing. That could be a whole nother show. So, but the difference is the taxation difference and the inheritance difference. But even if you have the LLC, if you'll remember what I said last week, there's something called succession planning if you have a business. So you still have to have a plan in place for what's going to happen to that business when you pass. Is it going to go to a partner? Is your child going to take it over? Is it someone you trust who will dissolve the business and then give all the assets to your family members? That's what's in my trust. I have friends that are lawyers who will know to come in, and they'll know, especially if you have a licensed business, a lawyer, a CPA, a doctor with a practice, something like that. You have to have another licensed person come in and wind that business down. Tell all the clients, okay, this is what happened. Like when my dad passed, when my dad's accountant passed, we got a letter from the accountant that said, from the accountant next door that said, hey, this accountant, he passed away. We see you were one of his clients. We have your file in our office. We're happy to take over the service, or you can come pick up your file. That was succession planning. My dad's accountant had a plan, which was namely, sounds like maybe it was an office sharing or a building with several accountants in it. And they were all probably solo accountants. And he just asked the person in the office next door, hey, will you, wind down my business? Will you help, if I pass away and something happens? So that's succession planning. That's what needs to happen. So it's still, even if you have an LLC and you run it that way, it still ties in to some kind of estate planning. Because it's getting to be 7, I will look. Let's see. That's what's included in the package. Sounds like LLC. I don't think I missed any questions. So I want to respect everyone's time, and I'm so grateful that you guys came and listened. And next week, I believe the class is about home buying and home selling. So looks like interest rates are coming down. The market's trying to make a little comeback. So what do we need to do if we want to buy? What do we need to do if we want to sell? Real estate is very much about the local market and what's going on in the local market, but there's some basic tips and information, some behind the scenes information, terminology, things to think about, that we can talk about to make sure that you're ready, because it's definitely the time of year as we move into spring, and then definitely when summer comes, If you got property you want to move, let's try to move it. If you got property you want to buy, let's try to help you buy it. So I am grateful for everyone. Thank you so much. Not seeing any more questions. I always want to make sure I don't leave people hanging. But just in case, you have the Calendly link and the office number is there, and then the email address. And so, all right, guys, y'all have a great night, and thank you so much. I'll see you next week.